Julian Assange is currently being held in Belmarsh prison, where he is on remand pending the outcome of his appeal against his extradition to the United States, which has already been approved. For why he is in prison in the first place and why he has not been released on bail pending his appeals, check out these two videos where I go into much more detail. In this video, I'm going to explain how the extradition process has progressed through the courts and what options remain for Julian Assange after his appeals have failed so far. Welcome to my channel, Andy on Crime, where I talk about high-profile criminal cases and other aspects of criminal law. Now, as I've said in my previous videos, I know there are very strong opinions in relation to the continued incarceration and the extradition proceedings against Julian Assange to the United States, and some of the facts are disputed. In my videos, I do try to be as balanced as I can in outlining what has happened, but I appreciate that there are different narratives and some of what I say will be disputed, and feel free to correct me in the comments if I've got anything wrong. With that being said, let's get into the video. In terms of recapping how the extradition process started, I'm going to let this funny looking guy explain where we are. On the 23rd of May 2019, he was indicted by the United States on 17 counts of violating the Espionage Act 1917 for his alleged role in obtaining and publishing secret military and diplomatic documents in 2010. The specific charges were conspiracy to obtain and disclose national defence information, conspiracy to commit computer intrusions, obtaining national defence information, and disclosure of national defence information, and the charges carry a maximum sentence of 170 years in prison. On the 13th of June 2019, the then Home Secretary Sajid Javid stated that he had signed an order allowing Assange's extradition to the US over hacking allegations. The following day, Julian Assange appeared at a hearing at Westminster Magistrates Court in relation to the approval of his extradition by the Home Secretary. The Chief Magistrate, Emma Arbuthnot, ordered that a full extradition hearing should begin on the 25th of February 2020, and that this would be an opportunity for Julian Assange and his legal team to contest his extradition to the United States. The judge, Emma Arbuthnot, recused herself from the case in autumn of 2019 over a perception of bias that could have arisen given her husband's alleged employment in the intelligence industry. District Judge Vanessa Barretzer took conduct of the case and held a case management hearing in the latter part of 2019 before proceedings began in February of 2020. During the proceedings, Julian Assange's lawyers argued that he could not be extradited because the offences with which he was charged with were political offences for which extradition between the UK and the US was not permitted. Due to the COVID-19 pandemic, the case was then adjourned for several months, and in that period, in June of 2020, Julian Assange was indicted with a further 18 offences, including plotting to hack computers and conspiring to obtain and disclose national defence information. His legal team attempted to have these new charges thrown out, but this was rejected by the judge. The judgment of District Judge Vanessa Barretzer was delivered on the 4th of January 2021, and she found in favour of Julian Assange, barring his extradition, stating that she was satisfied that his mental condition is such that it would be oppressive to extradite him, and that is the test that is laid down in Section 91 of the Extradition Act 2003, which, if satisfied, would bar someone's extradition to another country. Now, following the judgment, Assange again applied for bail, but this was refused and the United States were allowed to appeal the judgment, and the case continued to the High Court. The United States had 5 grounds of appeal, which I will briefly summarise, but on the screen you can see the full grounds of appeal that were outlined in the judgment by the court. Ground 1 is that the judge erred in her application of the test under Section 91 of the Extradition Act 2003. Ground 2 was that having decided decided that Section 91 was met, she should have informed the United States to allow them to make assurances to the court over Assange's extradition. Ground 3 was that having found the principal defence psychiatric expert had misled her during their evidence, she should have ruled his evidence incapable of being relied upon. The fourth ground was that the judge erred in her assessment of the risk of suicide in this case, and ground 5 was that the United States had now provided assurances with regard to the detention of Julian Assange in the United States, and that any custodial sentence awarded, if he was convicted, would be served in Australia rather than the US. The High Court, in its judgment on the 10th of December 2021, which I put a link to in the description, allowed the appeal on the basis of grounds 2 and 5. This is the grounds relating to assurances which had now been provided, and it rejected grounds 1, 3 and 4. Now, the judgment quashed the order preventing Julian Assange from being extradited, and the case was sent back to Westminster Magistrates Court. Julian Assange also continued to be remanded into custody whilst proceedings were ongoing. On the 24th of January 2022, Julian Assange was granted permission to petition the Supreme Court, this is the highest court in the land in the UK, for an appeal hearing, but this request was refused by the Supreme Court on the basis that Julian Assange had not raised an arguable point of law. In April of 2022, back at Westminster Magistrate, the now Chief Magistrate Paul Goldspring approved Julian Assange's extradition to the United States, and the case was referred to the Home Secretary for final approval. This approval was granted on the 17th of June 2022 by the then Home Secretary Priti Patel. So just to briefly recap to this point, the original extradition request was rejected by the court, but the United States then appealed to the High Court and won, leading to the case being sent back to the original court, Westminster Magistrates Court, who then approved Julian Assange's extradition, and this was given final approval by the then Home Secretary. This was not the end of the matter, however, as Julian Assange had the right to appeal to the higher courts against his extradition, which he duly did so. On the 1st of July 2022, he lodged an appeal at the High Court, as well as a separate appeal to the European Court of Human Rights. But both appeals were rejected, with the ECHR stating that his appeal was inadmissible, and the High Court stating that none of the 4 grounds of appeal that had been submitted by Julian Assange's lawyers properly raised any arguable point. Now, the latest position is that Julian Assange has one final hearing in February of this year at the High Court. If that appeal is rejected, then it would appear that he has exhausted the legal process to prevent his extradition, and it will be highly likely that he will be deported to the United States to face those charges in the 2 indictments against him. Now, a number of high-profile individuals and organisations have consistently called for Julian Assange not to be extradited to the United States. This includes organisations such as Amnesty International, and in my previous video I outlined the statement that they put out in relation to his extradition. But it seems even now some US politicians are calling for him not to be extradited, including the unlikely duo of Alexandria Ocasio-Cortez, the Democrat, and the Republican Marjorie Taylor Greene. That's all for this video. If you do have any comments, then please drop them down below. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.